exceptions to consideration. Now we have seen that the consideration is the lifeblood of any contract, but the rule or the law says no consideration, no contract. If there is no lawful consideration for both the parties in the contract, the law says it is a void contract or contract which cannot be enforceable by law. Therefore, all consideration must be lawful and any unlawful consideration are considered as void. But there are few exceptions given by law where a contract can be enforceable though there is no consideration. That means under these exceptions only one party is receiving, okay, but the person who is receiving that consideration is not doing any kind of work or any kind of activity in return. Is that clear? So there are two parties to a contract, but only one person is receiving the consideration, the other is not receiving anything. But the law says yes, under few circumstances such cases or such contracts are enforceable or valid in the eyes of law. The first one, natural love and affection. The agreement without consideration may be valid if it is in writing and registered and is made on account of natural love. Example, A out of love promises to give his son rupees 10,000. A puts his promise to be into writing and registered it. Hence, there is a contract. Now here, A is not receiving anything for 10,000 that he is paying to B. Okay, so only one party is receiving the consideration here, that is Mr. B. Mr. A, is he receiving anything? No, but still this contract is enforceable by law, because why? It is an exception, that is natural love and affection. So if there are parents gifting any kind of property, writing any will in the name of children, even though children have not committed any kind of work or service to parents or to the other party, it is still termed to be as what? Enforceable by law. Basically, it's a valid contract. So the first exception to consideration here is natural love and affection. Second, compensation for services rendered. According to section 25 subsection 2, the law says if it is a promise to compensate wholly or in part a person who has already voluntarily done something for the promiser. Now here we have studied across the first essential, consideration may be past, present and future. You remember that we have discussed those three points under the essentials of valid consideration that applies here. That is example, X finds Y's purse and gives it to him. Y promises to give rupees 200 to X as a compensation. Thus, there is a contract. Now here X and Y have not mutually agreed upon this this activity of losing or finding the purse, neither they are intentionally into a legal contract. But then X finding Y's purse is a past event, correct? It is a past event, the activity has already been completed. But then Y is promising to pay him as a reward or as an appreciation right now. So therefore, it is a compensation for services rendered. So this also is one of an exception under the consideration, compensation for services rendered. Point 3, time barred debt. According to section 25 subsection 3, a promise to pay a time barred debt is also enforceable agreement. It must be in writing and signed by the promiser. An oral promise is not enforceable. First, let's understand what is time barred debt. Now, in case X has bought some goods from Y, X has bought some goods from Y and therefore X has to pay the price of the goods to Y. But X fails to pay the price of the goods to Mr. Y. Now, according to law, in case you want to file a case against somebody who has not paid you a compensation or paid you the price of a goods in this, for this example, there is a time limit. Okay, there is a time limit by which you can take a legal action upon the person who has defaulted the payment to you. Once the time period by law, maybe let's say it's 3 years or 1 year or whatever the time period given by law, has been crossed over, okay, and you haven't taken any kind of action, that is called as time barred debt. That means the person has not turned up to pay, neither have you taken any legal action upon them. Now once the time has barred, then if you are deciding to take a action upon them, then it is not possible. It is not enforceable by law. But then if that person comes back after time is barred, that is time has been completed to pay back, again if he comes back and says, I will now pay back, give me another 1 month time. Okay. So this promise again must not be oral, because oral promise is not what? Enforceable by law. He must give it in writing, yes, I am willing to pay for whatever goods I have purchased from you, I am willing to pay the price of that goods within 1 month time period. In this case, now Y can file a case in case now he defaults it. Is that clear? Now Y, again does he have to provide goods for him? No. His work is already completed priorly. It was X who did not pay or defaulted the payment. And now after the time is barred, if he is coming back and again promising to pay him back the money in a written agreement or in a written statement, then keeping this as a legal document or as a promise or as an agreement, Mr. Y can file a case against the X if this time he is going to default again. But in this new agreement, is Y performing anything? Is Y again selling the goods? No. In this time or in this time of agreement, only X is supposed to pay. So one person is doing some activity and Y is not doing anything right now. Is that clear? So there is consideration that Y is going to receive now and X is not. So this, in this case, it is called as exception to consideration under the topic time barred debt. Hope you have understood this topic. Fourth point, completed gift. Under section 25 of the Indian Contract Act states that nothing in the section shall affect the validity as between the donor and the donee is needed to create an agency. Now in case we gift each other in terms of birthdays or weddings or marriage, etc., correct? Now that gift is a completed gift. Now why do we call as exception? Because it is my personal opinion or a choice to gift someone. Okay, the other person may not have to do any kind of service to me or activity or any kind of work to me, but out of love or affection or out of the friendship that we have with the other person, I agree to gift that person a sum of rupees or an asset, for which the other party who is receiving the gift do not have to perform any kind of activity. So this case is also enforceable by law. Have you heard about the gift deed? Okay, you can give a gift deed as in a check, or you can gift a property, etc. Okay, so this is called as an exception to consideration. The other party is not performing any kind of work to receive that gift, yet the law says gift is a enforceable agreement by law. Moving on to the last 2 points, the fifth one says agency. According to section 185 of the Indian Contract Act, it says there is no exception to the general rule. Under the above section, it says no consideration is needed to create an agency. Now, if I am appointing a person, I have a supervisor under me or an assistant under me. Okay, so I send him to enter into a contract with another person. On whose behalf? On my behalf. Agent is going to enter into an agreement on behalf of the principal. Now he is my servant or he is my assistant, so I just ask him to enter into the contract with a X party or a certain party. Now here, does agent have to perform certain goods or perform certain activity? No, he is just doing all the work on behalf of the principal or his master. Therefore, agency, you do not have to pay anything to him, because by duty or as a servant to his principal or a boss, he is bound to do whatever his master is asking him to do so. Therefore, he does not have to perform any kind of activity to enter into the contract. So, as an agent, still the person can enter into the contract on behalf of his master or behalf of his principal. Law says yes, in this case the contract is valid or the consideration is still valid. So, therefore, this is an exception to consideration. The last one, guarantee. Under section 127, the contract says, Indian contract says, a contract or an agreement of guarantee are made without consideration. If I have just asked a well-known friend, okay, it's a contract between me and a third party, another party, and I ask my friend to stand as a guarantee for the agreement. In case I make to, if I am going to default in terms of paying, okay, or fulfilling my obligations, this guarantee or the person I am going to bring in between the contract will stand as a guarantee to the contract. In case I default, here is a person who is going to pay on my behalf. So, here guarantee is another exception to a consideration. Now, he does not have to perform any kind of duty or I need to pay him for being a guarantee. He is just a good friend of mine. Probably based on friendship or love or affection, I can ask him to be as a guarantee to a particular agreement or to a particular contract. Therefore, the law says even in this case, the consideration is valid or enforceable by law. So, these are the 6 different exceptions to a valid consideration, starting with natural love and affection, compensation for services rendered, time-barred debt, completed gift, agency and guarantee.